So let's start today's lesson. Theme number 2: criminal procedural law of Ukraine, criminal procedural legislation. And as always, we will start with the vocabulary. Bilateral, двосторонній, Commissioner of the Верховної Ради of Ukraine for Human Rights, Уповноважений Верховної Ради України з прав людини, Convention on Cybercrime, Конвенція про кіберзлочинність, Convention on the Protection of Human Rights and Fundamental Freedoms, Конвенція про захист прав людини і основоположних свобод. Sometimes you will hear the definition European Convention. So European Convention is an unofficial name for the Convention of the Protection of Human Rights and Fundamental Freedoms. Next, Council of Europe Convention on the Prevention of Terrorism, Конвенція Ради Європи про запобігання тероризму, Criminal Law Convention on Corruption, Кримінальна конвенція про боротьбу з корупцією, Custody, тримання під вартою. So, sometimes we will use the term arrest, but the more correct term in criminal proceedings is to take someone into the custody. Когось обирати запобіжний захід у вигляді тримання під вартою. Deputy of Local Council, депутат місцевої ради, discretionary method, диспозитивний метод, European Convention on Extradition, Європейська конвенція про видачу правопорушників, European Convention on Mutual Assistance in Criminal Matters, Європейська конвенція про взаємну допомогу у кримінальних справах, European Convention on the Suppression of Terrorism, Європейська конвенція про боротьбу з тероризмом, European Convention on the Transfer of Proceedings in Criminal Matters, Європейська конвенція про передачу проваджень у кримінальних справах, European Court of Human Rights, Європейський суд з прав людини. Please remember this term, European Court of Human Rights, because we will often use it. Gaps, прогалини. Gaps in the law, gaps in the legislation. For example, when legislation does not give us any direction how to act in some specific situation, we can say that there is a gap in such legislation. Homogeneous, однорідний, interrogation, допит, interrogation as an investigative search action. Irrespective, незалежно. Law of Ukraine on the bar and practice of law, закон України про адвокатуру та адвокатську діяльність. Law of Ukraine on the enforcement of judgment and the application of the case law of the European Court of Human Rights, закон України про виконання рішень та застосування практики Європейського суду з прав людини. Law of Ukraine on the judicial system and the status of judges, закон України про судоустрій та статус суддів. Sorry. Law of Ukraine on the national police, закон України про національну поліцію. Law of Ukraine on the public prosecutor's office, закон України про прокуратуру. Law of Ukraine on the security service of Ukraine, закон України про службу безпеки України. Legal successor, правонаступник. Ukraine is a legal successor of the USSR in some international treaties about which we will talk later. Penal Code, Кримінально-виконавчий кодекс. People's Deputy of Ukraine, народний депутат України. Search as an investigative search action, обшук. Treaty, договір, unconditional, безсумнівний або безумовний. So, first question is the criminal procedural law of Ukraine, subject and method of legal regulations of criminal proceedings. Criminal procedure law is one of the branches of the legal system of Ukraine, a set of legal norms regulating activities of particular investigation bodies, prosecutor's office and the court, as well as other individuals and legal persons during criminal proceedings. So, if we are talking about the definition of criminal process, we are talking that criminal process is some kind of process. So, it's a set of actions by the investigator, public prosecutor, investigating judge in court, and other participants in criminal proceedings. So, criminal procedure is a set of actions. If we are talking about criminal procedural law, it's a set of legal norms which regulate criminal procedure in general. Criminal procedure law is an independent branch of law because it has its own subject of legal regulations and its specific method of legal regulation. But if we are talking about the criminal procedure law, we must say that there is a very deep connection between criminal law. So criminal law and criminal procedure law are deeply interconnected because they have, technically they regulate the one specific sphere of our life. According to the specific nature of criminal procedural relations, the criminal procedure is predominantly applied by the imperative method of legal regulations, although there are a lot of elements of discretionary method. For example, suspect has the right to choose the tactic of his defense in court, to use his rights at his own discretion, and so on. So if we are talking about the methods of the legal regulation of criminal procedural law, as in other branch of law, criminal procedural law has two main methods of legal regulation: imperative method and discretionary method. Imperative method, if we are talking about the imperative method, if we are talking about some sort of obligation that must be fulfilled by the participants in criminal proceedings. For example, if a person will be kept into the custody, it's like his obligation to be kept into the custody. So he cannot, for example, walk from a jail. We understand that criminal procedural law is a very specific branch of law because, once again, we are talking about the crimes. We are talking about the most severe misdemeanors that can be that we have in our legal system. So the imperative method is one of the most important methods of legal regulation in criminal proceedings. Yet it will be wrong to say that there is no discretion, because once again, there are some rights that can be fulfilled or enjoyed by the participants of criminal proceedings by themselves on their own discretion. I remind you, discretion розсуд. So on someone's own discretion, на чийсь особистий розсуд. For example, as you can see, it's a right of suspect to use his own rights at his own discretion to choose the tactics. For example, a suspect and the victim can sign an agreement between them, for example, to close criminal proceedings. In that case, we also can say that in this specific situation, the discretion method will be applied because it's not an obligation for a suspect or victim to sign such agreement between each other. We are talking about the will to sign such agreement. So we are talking about the discretionary method of the legal regulation. Sorry. The subject of criminal procedural law is social relations that arise, exist, change, and end in connection with the implementation of specific criminal proceedings, pre-trial investigation, and trial in connection with the commission of the crime. Okay. What I forgot to make, and you didn't tell me, is to probably put my presentation. Sorry for that. Now you can see. Once again, all the terms that we previously mentioned. And our first question. Social relations become criminal procedural relations only under the regulation of the criminal procedural legislation. There are three elements of criminal procedural relations: actors or subjects, all state bodies, the officials who carry out criminal proceedings, as well as other citizens, officials, and legal persons involved in criminal proceedings. Objects, the ones that cause the emergence and development of criminal procedural relations. Procedural rights and procedural obligations of the subject of criminal procedural relations. Criminal proceedings can take place only in the form of criminal procedural relations. There is no other way to use rights and fulfill obligation by the subject of criminal proceedings. So, as we previously mentioned for several times already, criminal process is a set of actions. So there has to be some active involvement of the participants in criminal proceedings, so that they can fulfill the rights, the obligations in criminal proceedings. Criminal procedure is a set of actions. So there has to be the active form of participation of different subjects in criminal proceedings. Also, it's important to understand that the specific features of criminal procedural relations is the mandatory participation of a representative of the state who carries out criminal proceedings. Criminal procedural relations could not exist without some state bodies or officials as a subject of criminal procedural relations. Once again, very important to remember. If we're talking about criminal procedural relations, we always must say that there will be a state official or state body in such relations. If, for example, we're talking that in the criminal procedural relations, there are only subjects who has rights but no powers, for example, suspect and victim, any types of relations between them are not criminal procedural relations. Let me explain it. For example, as I previously mentioned, suspect and victim could sign an agreement to end criminal proceedings. In general, we'll call this agreement agreement to end criminal proceedings. It will be enough for now. But if we're talking about any types of agreement between the suspect and the victim, for example, in the time when they set the rules about they're talking about the compensation and so on, so on, so on, all these questions cannot be applied as a criminal procedural relations. They cannot be identified as a criminal procedural relations because at the moment when they just agree the terms of such agreement, there are no obligations arise from such agreement at that specific moment. And only when suspect and victim will come to the, for example, investigator and told him that they set an agreement and they will sign an agreement in the before the investigator, or they will give this already signed agreement to the investigator, only at that moment rights and obligations will arise in criminal proceedings. So there is always must be involved, there's state official must be involved in criminal procedural relations. Another example. For example, signing an agreement between the attorney and suspect. Because as you maybe know, if attorney wants to be a defense counsel in criminal proceedings, he must have some documents that will give him permission to enter this specific criminal proceedings. One of these documents is an agreement between the attorney and his client. Once again, at the moment of signing such agreement, still no rights and obligations in criminal proceedings will arise at the moment of signing. And only when attorney will show such agreement to the investigator and will introduce himself as a defense counsel in criminal proceedings, only at that moment he will receive rights and obligation in this specific criminal proceedings. So once again, a state official, in our case investigator, must be involved in criminal procedural relations, So I must emphasize on this, all criminal procedural relations must involve any type of state officials or state bodies who has some powers in criminal proceedings. Criminal procedural relations arise only after the receipt of the competent law enforcement authorities and information, about criminal offense which has committed or under preparation. So criminal procedural relations will arise only when the state officials will receive an information about the criminal offense. It should be noted that the commission of a criminal offense does not always lead to the emergence of criminal procedural relations, since not all criminal offenses become known to the competent state bodies or officials. At the same time, false reports of the criminal offense led to the emergence of criminal procedural relations. What does it mean? It means that criminal procedural relations begin when the state officials receive an information about the possible criminal offense. It will be wrong to say that the criminal procedural relations arise when the crime was committed, because some of the crimes will stay unknown to the state officials. For example, no one reported about it, so we don't know about the crime. So criminal procedural relations will not arise. And in other cases, there could be some false reports about criminal offenses that in real whenever never appeared in the criminal proceedings. And if we're talking about these false reports, the investigator must begin pretrial investigation, because at this specific moment, at the start of pretrial investigation, there is no clear information that this report is false. So criminal procedural relations will arise on the false reports in this specific situation. So once again, if we're talking about the arising of criminal procedural relations. We're talking about the moment when the state officials receive information about criminal offense. Any legal procedural relations have their own object. The range of possible objects of criminal procedural relations is very wide. For example, the conduct of procedural actions, such as receiving testimonies during interrogation, the adoption and execution of procedural decisions, conducting such actions, or certain behavior, violation of the order in the courtroom, etc. Criminal procedural relations has an actual and legal content. The legal content of criminal procedural relations is established in the norms of law, procedural rights and obligations of the subject. The actual content of criminal procedural relations forms the real actions of the subjects aimed at the realization of the rights and obligations, which are determined by public or private interest in criminal proceedings. So legal content is the possible actions that can be made during criminal procedural relations. So it's the limits which established by the criminal procedural legislation, limits of rights, for example, that can be enjoyed by the participants of criminal proceedings. Actual content are the actual actions that will be conducted by the participants, or actual specific rights that will be enjoyed, fulfilled by the participants in this specific situation, in this specific criminal proceedings. Sorry. Rules of criminal procedural law, their structure. Rules or norms. We're talking about this, the smallest part of the criminal procedural law, which is called, in some case, rule, or in other case, it's called norm. Criminal procedural law is a legal source, an external form of criminal procedural law, since it represents a way of expressing criminal procedural activities and the functioning of its norms. Rules or norms of criminal procedural law are the mandatory rules of conduct of the subject of criminal procedural activity, which formally defined in the law and the execution of which is provided by the state authorities. Typically, these mandatory rules of conduct are performed voluntarily, but in some cases, the enforcement of is ensured by the force of state coercion. Please remind you, coercion primus. So, as we previously mentioned, there are two main methods of the regulation of criminal procedural relations: imperative and discretion. And states think that almost the biggest part of the obligations of participants in criminal proceedings will be fulfilled by themselves with no state coercion. But in some cases, it's possible to use such coercion, for example, to use any measures of restraint in criminal proceedings to force participants to fulfill their obligations. The criminal procedural norm is characterized by the following features. It's general accepted rule of conduct formulated by the state, and they are obligatory. So any norm, as any legislation of any other sphere, is obligatory by all citizens of Ukraine, by any participants of criminal proceedings. It's a formally determined rule of conduct. The right and obligations of participants in criminal proceedings, as well as sanction for violation of established norms, must be secured by the law. This is a rule of general conduct. The rule of conduct is addressed not to a particular person, but applied to all who are subject of criminal procedural relations. We have some specific norms in our criminal procedural court of Ukraine that are addressed to a specific group of participants. For example, People's Deputy of Ukraine, judges, and so on, so on. There is a specific procedure for example, trial investigation if suspect was a judge or People's Deputy of Ukraine or defense attorney or something like that. But once again, these norms address not to a specific person, but to a specific group of persons without any individualization. It's very important to understand that it's not the violation of the equality of the law. It just, in some cases, simplification, or in other cases, just such group of participants in criminal proceedings will receive additional rights and guarantees because they have, for example, a very specific status, like a judges or People's Deputy of Ukraine. Fourth, it's a rule of conduct that become obligatory in a defined manner. The norm becomes a rule when it's issued by an authorized body within its competence and within the established procedure. So we're talking about the procedure of the adopting of legislation by Verkhovna Rada of Ukraine. Fifth, the state ensures the rule. The state creates real conditions to ensure the rule and create means of encouragement, persuasion, and sanction for not fulfillment of requirements of the rule. It's again quite clearly to understand, quite easy to understand. The rule of criminal procedure law can be conventionally divided into guard rules and regulatory rules. Guard rules regulate criminal procedural liability, and regulatory criminal procedure rules include rules that directly regulate criminal procedural relations by providing participants with the possibility to use their rights and assigning responsibilities to them. The structure of criminal procedural law is not always obvious, but as well as a rules of any other branch of law, it consists of three parts. So every norm in criminal proceedings, as in other branch of law, consists of three parts: hypothesis, disposition, and sanction. Hypothesis determines the condition in the presence of which this norm should be applied. Disposition contains the prescription itself, the rule of conduct, and the sanction implies consequences for the participants in the proceedings that occur when the norm was not fulfilled. So in general, if we're talking about the standard structure of norm, we can say that if hypothesis, then disposition, or in other case, sanction. If some conditions will be fulfilled, then participants must do something, and if they will not, the sanction will be applied. If, then, or, let's call it in general, if sanction, if a hypothesis, then disposition, or it will be sanction. The hypothesis and disposition of criminal procedural norm determine the condition and rules of conduct of the participants in criminal proceedings. They are usually formulated quite clearly in one article or part of it. If the court acquits an accused who was in custody, then the court must immediately release him in the courtroom. Once again, this is a specific norm of the criminal procedural in the Criminal Procedure Code of Ukraine, and we can clearly see the structure of this norm, more specific, the disposition and sanction. If, so condition, what kind of condition? If a court acquitted an accused who was into the custody. So there are several conditions that the person must be into the custody and the person must be acquitted by the court. So if this condition will be fulfilled, then someone must do something. For example, in this specific case, then the court must immediately release him from the courtroom. Quite clearly. Once again, there are some, let's not say problems, but complications with the sanction in criminal procedural legislation. Sanctions are often contained in other articles of the CPC or even in other legislative acts or formulated in relations of several homogeneous norms. So let's talk about for a little bit about the sanction. For example, some sanctions to the norm of criminal procedural legislation are contained in other procedural acts. For example, investigator could not use torture while interrogating a suspect. We can understand that if an investigator will use a torture while investigating a suspect, then the criminal sanction could be applied to such investigator. So once again, the sanction to this specific norm will be set in the criminal courts of Ukraine. So it's a criminal liability for the misconduct of the investigator during pretrial investigation. But also there are I must emphasize on this, there are criminal procedural sanctions. Criminal procedural sanction means that there will be some consequences for not fulfilling rules that are set by a criminal procedural court of Ukraine. For example, once again, let's talk about this example. It's impossible, it's prohibited to, sadly, it's possible to use torture, but it's prohibited to use torture while the interrogation of the suspect. Will there be any criminal procedural sanctions? Yes, it will be a very specific sanction. Most sanctions in criminal series are about the inadmissibility of evidence. Inadmissibility of evidence is one of the form of criminal procedural liability or criminal procedural sanction. So, for example, if some evidences were obtained with the use of torture, the sanction will be that this evidence will be inadmissible. Another example, according to the Criminal Procedure Codes of Ukraine, in some cases, the courts of the first instance must consist of 3 judges. These cases are established in the Criminal Procedure Codes of Ukraine. What will be the sanction if the courts conducted the trial by one judge by himself and not with a panel of judges? Once again, this such court decision will be judged by the appeal court, and the appeal court, for example, could dismiss such decisions and create a new one. So dismissal of the decision of the court of first instance will be a criminal procedural sanctions in this specific occasion. So once again, I emphasize that sanction does not always mean some kind of punishment to the participants in criminal proceedings. It means some negative consequences for not fulfilling the obligations or not fulfilling the duties that were established by the criminal procedural law. And inadmissibility of evidence is one of the most commonly used criminal procedural sanction in criminal proceedings. Unlike the criminal law, the use of criminal procedural law is possible and sometimes even necessary in analogy because there may be gaps in it. So you know that you cannot use analogy in criminal law, but it's okay to use analogy in criminal procedural law. To apply the criminal procedural law by analogy, the following conditions must be observed. The case provided by the procedural law must be like the law that applied by analogy. Use of analogy cannot in any way lead to the limitation of procedural rights of persons involved in criminal proceedings, and prevent the commissioning new powers of operational units, trial investigation agencies, prosecutors, investigation judge, or court that are not provided by the rules of the criminal procedural law. So if we are using analogy in criminal procedural law, no new powers to the state official state bodies would be created. Once again, their powers are limited by the legislation. As you know from the general theory of law, there are 2 types of analogy: analogy of law and analogy of legislation. We use analogy of legislation when we use some specific norms of any other legislation to fulfill the gap in our case in criminal procedural legislation. It's, for example, in some cases possible to use a civil procedural court of Ukraine during criminal proceedings when there was a civil lawsuit set by the participants of criminal proceedings. So once again, it's a possibility to use the specific legislation in this specific case, a civil procedural court of Ukraine. If we are talking about the analogy of law, we are talking about the analogy of If we're talking about the analogy of law, we are talking about the possibility to use general principles in criminal proceedings, for example, rule of law. And according to the Article 9 of the Criminal Procedural Court of Ukraine, if there are any gaps in the criminal procedural legislation, or if there are any problems with the understanding of some specific rules, it's possible to use general law principles that are established by the Criminal Procedural Court of Ukraine. So, for example, if there is very specific gap that could not be fulfilled by any legislation, the court is allowed to interpret this norm by himself with the usage of criminal procedural principles. Once again, if for example, judge will use the analogy of law in this specific case, he must use it in the favor of a suspect, for example, victim, in the favor of the participants of criminal proceedings. Once again, it's established by the Criminal Procedure Court of Ukraine that we are allowed to use analogy of law in criminal proceedings. And sadly or not sadly, there are a lot of occasions in criminal proceedings when the analogy of law is still using quite widely. by the state officials, state bodies. Question number 3. Concept types of sources of criminal procedural law. So we are talking about the general, we're talking about criminal procedural legislation. We're talking about the sources of criminal procedural law, a list of which is technically established by the Article 1 of the Criminal Procedure Code of Ukraine. But if we are talking about the question more widely, we must say that the list of sources of criminal procedural law is bigger than it's established in the Criminal Procedural Code. Sources of criminal procedural law of Ukraine are the forms of consolidation of criminal procedural norms which regulate criminal procedural relations and were established by state authorities in the legislative, executive, and judicial sphere, as well as those contained in existing international treaties and in the practice of European Court of Human Rights. The main source of criminal procedural law in Ukraine is the law. Consequently, criminal procedural activities and criminal procedural relations are regulated by the norms of law, which are expressed and enshrined in the criminal procedural law. Article 1 of the Criminal Procedural Code of Ukraine states that the criminal procedural law of Ukraine consists of the relevant provision of the Constitution of Ukraine, international treaties the Verkhovna Rada of Ukraine has given its consent to be bound by, criminal procedural code of Ukraine, and other laws of Ukraine. So let's start from the top and move to the bottom. The Constitution of Ukraine has the highest legal force and direct effect on the territory of Ukraine. Laws and other legal acts are adopted based on the Constitution of Ukraine and must comply with it. The Constitution of Ukraine establishes that the bodies of legislative, executive, and judicial power exercise their powers within the limits defined by the Constitution and in accordance with the law of Ukraine. The norms of Constitution of Ukraine define the content and objectives of criminal procedural legislation, the principles and direction of the state bodies that carry out criminal proceedings, establish guarantees of the rights and freedoms of persons involved in criminal proceedings. For example, if you're talking about the Constitution, there is a very specific Article 62 of the Constitution, which in other words is called presumption of innocence. Presumption of innocence, a very important principle of criminal proceedings that could be applied only in criminal proceedings, is clearly established in the Constitution of Ukraine. For example, if you compare our constitution to constitutions of many other European countries or countries with a high level of democracy, you can say that not any constitution consists a specific guarantee, specific rights that could be applied only in criminal proceedings. For example, establishing presumption of innocence in the Constitution is, let's call it, our own speciality of the Constitution, because, for example, in the Constitution of Germany, I think of France, there is no defined specific presumption of innocence in the constitutional norm. The direct effect of norms of the Constitution of Ukraine means that a person has the right to apply to the court for the protection of constitutional rights and freedoms directly based on the relevant norms of the Constitution of Ukraine that justify his protection. The court is obliged to consider and resolve such applications irrespective of whether there are in the national legislation the relevant lower level rule that would govern the subject of the application. In the absence of a relevant legal norm in the national legislation, the court is obliged to protect the rights and freedoms of a person directly based on the norm of the Constitution. Norms of the Constitution may also be directly applied in cases where certain criminal procedural rules conflict with the Constitution, as well as when there are gaps in the criminal procedural law. So, any participants in any sphere of law of Ukraine and in criminal proceedings also could apply directly Constitution when they, for example, ask the court to protect their rights and legitimate interests. So it's possible to directly apply the norm of the Constitution by the court, by the judge, while making a decision, even if there is no specific legal act that will give us the definition or understanding of this specific norm of the Constitution. Criminal procedural legislation of Ukraine also include international treaties. According to Article 9 of the Constitution of Ukraine, valid international treaties Verkhovna Rada of Ukraine has given its consent to be bound by is a part of national legislation of Ukraine. Recognition of these treaties as part of national legislation is a new legal reality for Ukraine, an indication that Ukraine has also assumed responsibility for maintaining the rule of law in the world. So international treaties are also very important parts of criminal procedural legislation of Ukraine. Technically, we can divide all the international treaties which has some influence over the criminal proceedings of Ukraine into 4 big groups. First group, international conventions that define the legal status of a person in criminal proceedings, as well as requirements relating to criminal procedural mechanisms that ensure the protection of the rights and freedoms of a person in criminal proceedings. For example, Convention on the Protection of Human Rights and Fundamental Freedoms, or in other words, European Convention. European Court of Human Rights works on this convention because of this convention in order to protect the rights that were established by this convention. So please remember, Convention of the Protection of Human Rights and Fundamental Freedoms, or in other words, European Convention. European Convention on Extradition. European Convention on Mutual Assistance in Criminal Matters. European Convention on the Transfer of Proceedings in Criminal Matters. Next, international conventions that aimed at cooperation between states in criminal proceedings. European Convention on the Suppression of Terrorism. Council of Europe Convention on the Prevention of Terrorism. Convention on Cybercrime. Criminal Convention on Corruption. Third group, Ukraine's bilateral treaties on the legal assistance in criminal proceedings. We are talking about the treaties between Ukraine and any other states which has any influence on criminal proceedings. Agreement between Ukraine and the People's Republic of China on legal assistance in civil and criminal cases. Agreement between Ukraine and the Republic of Poland on legal assistance and legal relations in civil and criminal cases. Agreement between Ukraine and the Republic of Lithuania on legal assistance and legal relations in civil, family, and criminal cases. Agreement between Ukraine and the Republic of Moldova on legal assistance and legal relations in civil and criminal cases, and others. And the fourth group are international treaties in which Ukraine acts as a legal successor. Agreement between the USSR and the Hungarian People's Republic on the provision of legal assistance in civil, family, and criminal cases. Agreement between the USSR and the Republic of Finland on legal protection and legal assistance in civil, family, and criminal cases. Agreement between the USSR and the Algerian People's Democratic Republic on the mutual provision of legal assistance. Agreement between the USSR and the Republic of Cyprus on legal assistance in civil and criminal cases, etc. The important place among the laws regulating criminal procedural activities is occupied by the Codification Act, Criminal Procedural Court of Ukraine and others, Criminal Courts of Ukraine, Penal Court, and others. So we are moving to the third group of the source of criminal procedural law of Ukraine. These are the specific laws or specific legislation. If we are talking about the hierarchy of the laws in criminal proceedings, we must say that on the top of the list, we have a Criminal Procedural Court of Ukraine. Criminal Procedural Court of Ukraine is the most important legal act, if we're comparing to any other legal acts, as a source of criminal procedural law. Criminal Procedural Court of Ukraine was adopted on April 13, 2012. It reflects constitutional principles of criminal proceedings and principles of important international legal acts. The norms of the CPC of Ukraine are valid from November 20, 2012. So this November, it will be 10 years since the Criminal Procedure Court of Ukraine has taken legal effect. The procedure for criminal proceedings, which is established by the Criminal Procedural Court of Ukraine, is mandatory for all participants and is the same for all bodies conducted criminal proceedings. It's intended to provide most optimal conditions for the fulfillment of legal rights and interests of participants. Technically, I must give you a brief description of the criminal procedure code of Ukraine, yet I don't think that's very important because the amount of articles, amount of pages of criminal procedure code of Ukraine is not very important information. What you know, what you must know, that criminal procedure code of Ukraine is a specific legal act. It has some amount of criticism to it, yet once again, it was 10 years since it was adopted. So technically, all the most obvious problems were decided by the practice itself. So during the conducting of criminal procedural actions, some of the sharp edges were softened by the practitioners, by the investigators, prosecutor, by the judicial practice. So now we can say that more or less everyone understands what this code means, what he wants from the participants, and how obligations that are established in this clause can be fulfilled. In addition to the Criminal Procedure Code of Ukraine, criminal procedure law also include other laws of Ukraine. These other laws include those containing the rules relating to the procedure of criminal proceedings. For example, law on the judicial system and the status of judges, law on the public prosecutor's office, law on the security service of Ukraine, law on the national police, law on the bar and practice of law, etc. The norms of this and other laws of Ukraine must not conflict with the norms of the criminal procedure code. In the event of conflict between them, the priority to the CPC is unconditional. According to the Article 9 of the Criminal Procedural Code of Ukraine, if during the criminal proceedings there are any contradiction between criminal procedural code of Ukraine and any other legal act, we are not talking about constitution, we are not talking about international treaties, we are talking about legal acts. So if there are any contradiction, only criminal procedural code of Ukraine can be applied. So once again, if we're talking about mini hierarchy of the legislation of criminal proceedings, the top of all laws is the Criminal Procedure Code of Ukraine. It's the most important legislative act in criminal proceedings. All other laws can be applied only if there is no contradiction to the Criminal Procedure Code of Ukraine. Once again, it's the rules that are established by the Criminal Procedure Code itself in Article 9. According to the Article 152 of the Constitution of Ukraine, the decision of the Constitutional Courts of Ukraine are also the source of criminal procedure law. In decisions of the Constitutional Courts of Ukraine, laws, other legal acts, and their separate norms could be recognized as unconstitutional. In this case, the laws of or the separate parts cease to be valid. In addition, decision of the Constitutional Court formulates the legal position that are mandatory for use in criminal proceedings and for adoption by pretrial investigation agencies, prosecutor, investigators, and judges. So if we're talking about the decision of the Constitutional Court of Ukraine, we must say that there are two main types of the decision of the Constitutional Court of Ukraine. In the first type of decision, Constitutional Court can acknowledge any norm of law as an unconstitutional, and this norm could not be applied further by any subject, any participants in criminal proceedings. The second type of decision of the Constitutional Court of Ukraine is the set of legal position of the Constitutional Court of Ukraine, which establish how we must understand and apply very specific rule of the Constitution in the connection with some specific procedure. If we're talking about the Criminal Procedural Code of Ukraine of 2012, we must say that there were no legal position of the Constitutional Court applied to the modern CPC of Ukraine, but there were several decisions of the Constitutional Court of Ukraine in which Constitutional Court set some norms of the CPC as unconstitutional. The latest was in 8th of June 2022, when the Constitutional Court of Ukraine said as unconstitutional one of the options for closing criminal proceedings. If you are interested, you can read the Article 284 of the Criminal Procedure Code of Ukraine, Part 4, was set as unconstitutional, according to the very interesting decision of the Constitutional Court of Ukraine. I think it will be interesting for you to acknowledge with this decision. The impact of the procedure of criminal proceedings in our country has also the decisions and the legal position of the European Court of Human Rights. The court gives an interpretation of the European Convention on of the protection of human rights and fundamental freedoms. So, why we are interested in the case law of European Court of Human Rights? Because in his decision, European Court of Human Rights gives the interpretation of how to use European Convention or Convention on the Protection of Human Rights and Fundamental Freedoms. How can we understand and use some of the norms, some of the rights that are established in the European Convention? And as you know, Ukraine has signed this convention, so it's obligatory for our state officials, bodies, to fulfill all the obligations that are established by this convention. Yet, the convention was written not in the bright form, so a very specific court, European Court of Human Rights, was established to protect the convention from the violation of any state officials of any countries who have signed it. And European Court of Human Rights gives us definitions or understanding or interpretation how to use very specific norms of the convention. Decision of the European Court of Human Rights has some special features. The legal positions contained in them are normative. The decisions give an interpretation of the European Convention of the Protection of Human Rights and Fundamental Freedoms and the protocols to this convention. And decisions have a legal effect since they contain in decisions of a particular cases. So, while making a decision in the particular case about some specific person against some specific country, European Court of Human Rights also in this decision set a legal position that can be used by the judges, by prosecutors, by defense counsels to set an evidence or argument about his specific own position. The law of Ukraine on the enforcement of judgment and the application of case law of the European Court of Human Rights obliged the courts to apply both the convention and the case law of European Court of Human Rights during a trial. It's important to emphasize that the practice applied not only to cases in which Ukraine was a party, but to any other cases. So, according to this specific law, and according once again to the Article 9 of the CPC, courts and any other officials in criminal proceedings are obliged to use the practice of the European Court of Human Rights. So it's not their right, it's their obligation. If we analyze the practice, mostly the court practice about the usage of the case law of European Court of Human Rights, we can see that sometimes this obligation is fulfilled only by giving the same definition of the same court decision in any same definition of the same decision of European Court of Human Rights in any court decision. So it's a technicality problem about the usage of the case law of the European Court of Human Rights. Yet, once again, I must emphasize that we are obliged, and by we, I mean the participants in criminal proceedings, not only officials, but technically all other participants are obliged to use the practice of the European Court of Human Rights. Well, maybe it's an obligation for the state officials, but it will give a lot of benefits to the to any other participants, mostly to the defense party, to use such courts, to use such case law practice in any legal positions. The normative acts of the Cabinet of Ministers of Ukraine, Prosecutor's Office of Ukraine, Security Service of Ukraine, National Police, National Anti-Corruption Bureau of Ukraine, and others plays a certain role to the formulation of a procedure of criminal proceedings. These law enforcement authorities issue orders, instructions, and other acts. So any other state body, official body that are prescribed by the legislation can give a set of instructions, orders, and so on, that are obligatory to some specific parts of the state officials, for example, to all the prosecutors or to all investigators who work, for example, in the national police. But all these orders, instructions, and other acts must be complied with the legislation. They are lower on this set of hierarchy if we're talking about the laws. Also, I must say about the case law, usage of case law in general in Ukraine. In 2017, we had a very important changes in the Supreme Court. Before the 2017, we had a Supreme Court of Ukraine. Well, now we have a Supreme Court. Supreme Court is mostly used as a cassation in different cases, including criminal cases. But also a very important task of the Supreme Court is to set a stability to the usage of law by any other courts. So to set a stability to the court system by establishing how to use some legislation. So nowadays, Supreme Court, not Supreme Court of Ukraine, I'm emphasizing it because Supreme Court of Ukraine is a name of the court that was working before the 2017. But Supreme Court has the right, while making a decision, also to give his own interpretation of how to apply specific norm of legislation of Ukraine. So technically, it's something like European Court of Human Rights, but European Court of Human Rights interprets the European Convention, and Supreme Court interprets our legislation, any kind of legislation. And according to the legislation of Ukraine, the judges, and if the judges, probably the all other participants as well, are obliged to use the definition or interpretation that was said by the Supreme Court. So it's an obligation for the judges and to other participants, as we say, to use such decisions of the Supreme Court in their practice. So technically, if we're talking about the sources of criminal procedural law, we also must say about this specific case law by the Supreme Court, because once again, courts, any other courts are obliged to use such interpretation while making their own decisions. Next question: operation of criminal procedural legislation in time, space, and in respect of individuals. Operation of the court in space. It's Article 4, 5, and 6 of the Criminal Procedural Code of Ukraine. Operation of the court in space. Sorry. Criminal proceedings in the territory of Ukraine shall be conducted based on grounds and in accordance with the procedure specified in the Criminal Procedure Code whenever the place where a crime offense has been committed. So no matter where the crime offense has been committed on the territory of Ukraine, the Criminal Procedural Code will be equally applied to any criminal offense that was committed on the territory of Ukraine. Criminal procedural law of Ukraine shall also be applied in the course of proceedings initiated in respect of any criminal offense committed in the territory of diplomatic mission or consular post of Ukraine abroad, at the aircraft, sea or river ship which is outside of the boundaries of Ukraine under the flag of or distinguished emblem of Ukraine, if the home port of such aircraft or ship is located in Ukraine. So once again, we are talking about the definition of the territory of Ukraine, and you know that according to the legislation and according to the many international treaties, the territory of diplomatic mission, the territory of a ship, and territory of aircraft of Ukraine are also considered as a territory of Ukraine. So, for example, if we have a Ukrainian airplane who is flying to any other country and the crime was committed on this plane, then the criminal procedural court will be applied to conduct such criminal proceedings to this criminal offense. Whenever an international treaty to which the Verkhovna Rada of Ukraine consents to be bound extend Ukrainian jurisdiction to servicemen of the military force of Ukraine who are deployed in the territory of another state, proceedings in respect of criminal offenses committed in the territory of another state is in respect of such harassment shall be conducted as described in the Criminal Procedural Code of Ukraine. So if there was or there is or there will be any treaties which was signed by the Verkhovna Rada of Ukraine, which was adopted by the Verkhovna Rada of Ukraine, saying that our, for example, military mission, the territory where our military mission on the territory where our military mission CPC can be applied. So in this case, any crimes that will be committed on such territory will be once again conducted according to our criminal procedural legislation. In conducting in the territory of Ukraine an individual procedural actions at the request or commission of a competent organs of foreign state within the framework of international cooperation, provisions of the CPC shall apply. So if there is any sort of cooperation between our, for example, patrol investigation bodies and patrol investigation bodies of any other country on the territory of Ukraine, our legislation must be used. There are many cases, for example, if we're talking about transcontinental boundaries crimes, such as organized crimes, such as terrorism, and so on, so on, so on, where several countries are involved in the process of investigating such crimes. Some actions can be conducted also on the territory of Ukraine, but only within the scope of our criminal procedural legislation. If requested by a competent body of a foreign state, in the course of such procedural actions, the procedural law of this foreign state may apply, whether this is provided by the international treaty and the consent to the treaty has been binding given by the Verkhovna Rada of Ukraine, and where such international treaty of Ukraine is non-existent, this request has to be consistent within the current Ukrainian legislation. So another country can ask our country to use their own legislation, or not whole legislation, but some parts of it, while conducting procedural actions on the territory of Ukraine. In this case, we must first of all understand if there are any international treaties to this problem. If there is an international treaty about the usage of another country on the territory of Ukraine while conducting procedural actions, then we can apply such rule in such international treaty and give the permission to such state officials or state bodies to use their own legislation on our territory, but yet within the very limited scope. If there is no international treaty about that, then such problem, such question, such a request must be decided on the basis of the current Ukrainian legislation. We have some specific rules that can be applied while conducting such actions on the territory of Ukraine. Next, operation of the codes in time. Procedural actions shall be conducted and procedural decisions shall be taken into accordance with the provision of the CPC, which are applicable at the time when such an action has begun or such decision has been taken. So, if, for example, there will be any changes in the patrol investigation procedure, that any decision that were taken when the previous norms of the CPC have taken legal effect, then such norms will be applied while making such a decision. We are talking about decisions, and we are talking about the procedural actions in general. Admissibility of evidence shall be determined in accordance with the provision of the CPC, which are applicable at the time when such information has been received. Once again, if it's possible, if it's necessary, even after the slightly or not so slightly changes of the criminal procedure legislation, the evidence that were obtained before such changes still will be admissible because they were obtained in accordance with the legislation that was current at the moment of the requiring such evidence. And the last part is operation of the criminal procedure code in respect of individuals, in respect of a person. Criminal proceedings in accordance with the rules of the CPC shall be conducted in respect of any individuals, except some categories of persons that established by Part 37 of the Criminal Procedural Code of Ukraine. such as People's Deputy of Ukraine, professional judges, deputy of local council, defense attorneys, etc. So if we're talking about the individuals in criminal proceedings, all individuals are equal in criminal proceedings and have equal rights and equal obligations according to the criminal procedural legislation. Yet there is some very specific group of participants that because of the specific types of the obligations that are conducted, because they of the specific duties that they have, special additional guarantees will be applied to such individuals. For example, if you're talking about a professional judge, why professional judge has a more, let's call it in general, more rights in criminal proceedings when he's a suspect than any other simple suspect or suspect that is not a judge, because it's quite easy in other case to influence professional judge by the unlawful pretrial investigation to make some decision. For example, if a judge doesn't want to make a decision, if some, for example, official want to force judge to make some specific decision in a very specific case, he can, for example, force pretrial investigation agencies to begin the pretrial investigation against such judge and force him to make this specific decision. And in order to protect the independence of the judge, a very specific procedure for the pretrial investigation or for the criminal proceedings in general will be applied to this subject. So we are talking not about that not person are not equal in criminal proceedings. We're talking about that some group of participants in criminal proceedings need additional guarantees to protect them from unlawful influence. Criminal proceedings in respect of the individuals who enjoy diplomatic immunity may be conducted in accordance with the CPC only upon consent of such individual or the competent authority of the state, international organization such individual represents, in accordance with the procedure established by Ukrainian law and the international treaties of Ukraine. So if a person has a diplomatic immunity, it's impossible to start a general pretrial investigation and criminal proceedings against him if there is no consent of the state officials of this state. Once again, diplomatic immunity is quite important principle of the diplomatic relations in any countries, and Ukraine is also obliged to fulfill such obligations. For today, it will be all that I wanted to tell you about the criminal procedural legislation and criminal procedural law in general. Maybe you have any questions about today's lecture. I can answer them. I understand that you don't have any questions. Yes. In that case, thank you for your attention. You may be free for today. Goodbye.
Thank you so much. Goodbye.